Hello everyone, good afternoon. Welcome to this orientation session. So, are you all appearing for this year's mains this time? Okay, it's fine. See, I've given you a sort of a worksheet. Okay? Can you recognize these questions? They'll give you. Share. I think this is. Uh, hmm. Have you gone through the previous year's questions? To online students, I'll ask you to, if you have any doubt, please, you can ask your doubts, in the chat by writing your doubts in the chat box. Okay, so all of these are questions asked by UPSC previously. Mostly questions I've taken from last year, 25, 24, somewhere 22, 23. I've written that years. That is the purpose. So the purpose of this orientation session for optional guidance program, we have 20 lectures, right? I'll tell you very briefly what the purpose of this session is. The purpose of this session is to make you understand that how we are going to, address these issues in these 20 classes, right? The purpose is to make you go through the most important part of the syllabus. See, no one can really say ki in this year, or let's say in a subsequent year, questions will be asked from which area. But definitely, we can definitely, we understand based on what has been asked in the past, that certain sections have been asked. There is a way in which questions have been asked. So in these sessions, in these 20 sessions, what we'll try to do is that take up each part of the syllabus, and irrespective of its weightage, we'll at least try to understand the basics. And this also includes, I think this is the most concern, whether we'll be taking up matters on CLD, right? Because I understand that is one of the major concerns. So don't worry, the course has been designed in certain manner in which, as far as possible, proportionate weightage, necessity and proportionality, also one of the principles under international law. So based on necessity and proportionality, guiding based on these two principles, we have designed this course. And the idea is to, through these 20 lectures, again, to brush up your concepts, to make you understand what sort of questions have been asked. And also, let's say if there is anything, suppose if there is, let's say, a new judgment, let's say if any new issue, can you highlight any issue which is going on, which is important from our syllabus point of view? Anyone? Legally, talk legally, from a legal perspective. What governance issues? Governors issue, yeah, Article 200, 201, definitely. Safe harbor clause, rights of intermediaries to the newly 2026 IT intermediary guidelines, right? Are you aware about it? Okay. We also have, we are hearing about, I'm sure you must be reading the newspaper, then you know about various aspects, let's say with respect to personality rights, fair clause principle, or certain exceptions to copyright, development of artificial intelligence. Does this affect, any aspect of law? So yes, while going through these part of the syllabus, let's say even under international law, let's say law of the sea. So if there is any recent developments taking place, we'll take care of that. But mostly we'll take up the previous year's questions. And because these previous year's questions at least gives us an understanding. I'm not saying I'll take all of the PYQs, but most of the PYQs, especially those PYQs which you can say that ठीक है ये थोड़ा difficult है, not the regular ones, which we can skip, again depending whether you have understood the concept or not. So the purpose of this orientation session is to make you understand that how we are going to conduct those classes. As I've told you, it's based on those bifurcation of the syllabus into 20 parts. So today, let's start a discussion from today only. Let's assume that this is our first class, right? And accordingly, if you look at the questions, if you go through all the questions, I have in a way bifurcated it, like I cannot take all the subjects, like because paper 2 has a lot of subjects, but I've tried to include as much as possible in terms of the variety of the questions, and also in terms of, let's say, whether they are easy or not. So idea is not to, understand whether a topic is easy or tough. That may depend. हो सकता है मेरे लिए बहुत tough हो, and for you it might be easy, and vice versa, right? The idea is to understand the concepts in its comprehensiveness, and then to realize and to understand how to write those answers. So the main purpose of this session is to learn answer writing. if you ask me the essence, the summary, in these 20 lectures, we'll try to understand how to write coherent answers, what to be written in the introduction, how to structure the answers, and how should we conclude our answers, right? So that's the purpose of this lecture. Okay. So without wasting much of your time, read this question. Just read. I think this is also provided in your worksheet. And just tell me the essential requirement of this question. So with every question, this is how we'll take up those questions. We'll do a reverse engineering model. We'll see a question. You'll read those questions. We'll try to break up those components and how it will benefit you, because then you will understand that what is being asked in those questions. Chalo, batao, tell me. First question. Where does the Constitution of India vest executive power? See this. I'm underlining certain word. Okay. Where does the Constitution of India vest executive power with respect to subject matters in the concurrent list over which both union and states have legislative powers? Explain. This was a 10 marker. I think this was the first question, I guess, of last year's. So just tell me. All I am expecting you from as of now is you just tell me the components. Correct. So what does Article 73 and 162 tells us? Extent of executive power, right? Okay. More than the mechanical part, just tell me first what this question is asking. So this is, okay, we are going through the provisions. First tell me what this question is asking. So what are we supposed to write? What's your name? Amit. Yours? Vaibhav. Avi. Aru. Tell me. Quickly. I'm simply asking what this question is asking and what do you understand by this question? Mm-hmm. 3. Correct. Because see, I've underlined 3 important parts. Where does the Constitution of India vest executive power? So the Constitution of India vest executive power in these provisions. Again, I'm just breaking it with respect to subject matters in the concurrent list. Now, concurrent list is list 3. And it is provided under, let's say, Article 246, the Genesis, and obviously 7th schedule. I'm just breaking it into components over which both union and states have legislative powers. So yes, under concurrent list, both the union and states can make laws or legislate laws. Do you agree? Right? But this question is asking, where does the Constitution of India vest executive powers? So now tell me how or what do you understand first? And obviously then how do we go ahead with it? So if you just simply write that, let's say both union and states have legislative powers, is it good enough? No? Very clearly. Then what should we write, Abu? Abu, right? Aru, sorry. So you understand? This question tells us that, yes, let's say we are thorough with legislative powers, but we also need to be thorough with respect to administrative powers or executive powers, right? Because this is exactly what the question is saying. Where does the Constitution of India vest executive power? Now, Avi, what does these provisions say? 73 and 162? Okay, but what does this say? Correct. These provisions say simply that, let's say, Parliament has power under list 1 and list 3. Can we say this? To make laws. State legislature have power to make laws under list 2 and 3. So we see this is the common part between both of them. Correct? Now see, what does Article 73 says? That executive power of the union, the legislative power of the union shall be coextensive with the executive powers. So executive powers shall be, and same is written for states also. So executive powers shall be or shall run parallelly. If I use the mathematical formula of parallelly, shall run parallelly with legislative powers. Means to the extent both parliament and state enjoys legislative powers, it is to the same extent they enjoy executive powers. And how do we understand this? If you go through the provisions of 73 and 162. So this is how you have to structure your answer. Any other provisions which talks about executive powers in general? Let's say this question is asked in generally on executive power, vesting of executive power on center and states. So what are the provisions you would write? Correct. Both 256 as well as 257. Now what does 256 says? Extent of executive powers of the union. Basically it says that the executive power of the union shall extend to giving directions to the states. And states cannot impede, 257 says states cannot impede the directions given by the union. But this is a very generic provision. Yet you may address both these provisions, 256 and 257. What does 258 says? In fact, 257 also says that on certain, the center can give direction to states to execute laws, let's say with respect to any aspect of communication which is of national or military importance, national or military importance, right? Including railways. And further, it says, 257 also says that with respect to implementation of these directions given by the center, let's say some expenses are being made by the state. So those expenses which are made by the state shall be reimbursed by the center. And in case of any disagreement, it will be decided by an arbitrator to be appointed by the Chief Justice of India. This is what it says, right? But it does not specifically talk with respect to concurrent list. But it's a generic provision. If you talk about administrative relationship between center and states, obviously these are the provisions. 258 mein kya hai? Two parts, yes. President with the consent of state ask the state authorities to implement some of the central laws. Parliament does not need any consent. So Parliament, let's say if make a law either on list 1 or list 3, then it can ask the states to implement the laws. Okay? Now you are following the difference also, legislative relationship and administrative relationship. But what is your opinion on this question? Tricky, simple, kaisa tha? But only if you understand the concept, right? Because the word concurrent list, legislative powers at times may mislead you. It's possible. So we have to read the questions very carefully. Your comprehension skills will come into play here, right? First suggestion, please read the questions very carefully. Even if you are aware, let's say, even if you have studied the previous day or the previous night, still, at times what actually happens is that, let's say you have revised something, previously, and you are seeing the question and very happy, arey, same question has come. But read it very carefully. Okay? Can you give me a structure with respect to this answer? How should we go ahead with this answer? So what shall we write in the introduction? What shall we write as part of the body? And obviously, how shall we conclude the answer? Obviously, once we understand the concepts, then this is the problem. So tell me, introduction mein, how will you introduce your answer? So first step is knowing the content, knowing the concepts, understanding, let's say, whatever are the case laws, and then obviously fill the gaps through a structured format. This is the purpose of this orientation. This will be the purpose of the remaining 20 classes also. So I think whatever questions you have, let's see how much we are able to discuss. The idea is to discuss as much as possible, right? Quickly. Introduction, any one of you. How shall we introduce our answer? एक problem सुना है, starting problem. This is what actually happens. Now I have told you what to write. Now you have to implement that direction. So what you know, but now we have to determine how to write an answer. Okay. So these are very basic, simple steps. If you apply these steps, I'm sure it will help you. Not just here, everywhere else. Because see, the concept remains the same in terms of answer writing. The concept remains the same. If you understand a question, you almost understand 80% of it. This, you can say it's 20%. Because let's say if you're not even aware of administrative relationship, does not matter whatever you write here. It will not fit the bill, right? Quickly. So for your help, since this is the first question, go through the introduction and tell me, does it make any sense? Executive power with respect to subject matter in the concurrent list moves away from the constitutional rule under Article 73 and 162, where executive powers of the union and states are coextensive with their respective legislative powers. Now, it is highlighting a certain aspect. So it's saying it generally goes away from the general constitutional rule. What does it mean? No, they do not have. They are they are given. They do not have it. But चलो इसमें एक और issue क्या आता है? Problem is repugnancy will deal later, because it may happen, na? Both center and state making law on the same matter, both are inconsistent. That's a separate issue, but again it is interrelated. Let's say Parliament made a law on any matter under concurrent list. Suppose education, for example. Okay? So generally, when Parliament makes a law under concurrent list, generally, again, it's not a rule, generally, its execution or its administration is generally given to the states. I'll tell you some of the important aspects here. Generally, this is the rule. But it's also possible that Parliament can keep within itself because it has the sole authority. Legislative power is coextensive with the executive power. But it can also transfer this executive power to the state. इसमें कोई prohibition नहीं है. It's also possible that, let's say, Parliament made a law on union list. Even if the Parliament wants, then it can also ask the respective state governments to execute or implement the decision. The law. Total prerogative of the Parliament. And generally it is seen under list 3, concurrent list. When Parliament makes a law under concurrent list, the executive power is generally, it is seen that it is generally given to the states. Right? So when we talk about, I'm writing another word, residuary power. What does it mean? Entry 97 of union list, can I say so? So when we talk about residuary power with respect to legislative power, किसके पास होता है residuary power in terms of law making? Parliament के पास. But when we talk about implementation of these laws made under concurrent list, it is again generally understood based on examples and case laws that this residuary power of execution of laws made under concurrent list is generally given to the states. Execution की बात हो रही है or administration of these laws. So you see there is greater cooperation with the states. Center-states cooperation is much more, or it is more flexible when we talk about administrative relationship or even implementation of the laws, let's say, made under concurrent list. And it also strengthens the concept of cooperative federalism. Can we say this? So these are value added points which you can highlight as part of your answer. So we see what is the essence of this discussion, that as far as legislative relationship or legislative competency between parliament and state legislature is concerned, we see a lot of strictness. It's very strict, because then all doctrine of within substance will come into picture, right? If let's say it is assumed states feels or parliament feels that state has made a law which infringes upon the entries of, let's say, union list, and vice versa for parliament, if the state feels that parliament has made a law which infringes on the state list, then there is greater, these are list 3, both can make laws. This is union, this is states, this is list 1, this is list 2. I think this is not the, theek hai. So union can make a law under list 1 and list 3. State can make a law under list 2 and list 3. But union cannot make a law under list 2 unless there are special circumstances, and vice versa. So we see a lot of strict separation of legislative powers or legislative competence. But when we talk about the implementation of these powers, there is a lot of flexibility. Okay? So what I've done, I've brought these sort of a structure for you so that you understand what to write, how to write, same thing, nothing else. If you want, just go through it. So highlight that Article 173, this is what has been written. Executive power of the union shall extend to the matters with respect to which parliament has power to make laws, and union and concurrent list, Article 246, and to the exercise of such rights, authority and jurisdiction as are exercisable by the government of India by virtue of any treaty. Under Article 162, executive power of a state shall extend to matters with respect to which legislature of the state has power to make laws, obviously under state list and concurrent list. Then give certain examples, distribution of executive powers under concurrent list when laws are made by the center. So these are some of your examples. Sorry, legislative powers of the union and states for concurrent list are vested in Article 246 clause 2 on a concurrent subject. In exceptional cases, however, parliament may prescribe that execution of central law shall be with center alone or shared between center and states. And under the concurrent field, even after center assumes executive power under its law, residuary power of execution still remains with the states. Such allocation of executive powers with the states on laws made by parliament under concurrent list is an example of decentralization in the area of implementation of the laws. Are you able to find out those terms which you can feel that these are value added terms, which you can say enhances or elevates your answer? This also suggests a healthy relationship between center and states, thereby strengthening cooperative federalism. So when we are, when I was talking about the structure with respect to your answer, intro, your introduction at all time, no matter the marks, your introduction at all time should address the demand of the question directly, because we do not have neither time nor space. If a question is being asked on executive power, simply address or mention Article 73 and 162. If possible, mention other things also, whatever is possible. Since the question is on executive power, right? Does it justify? In some sense, at least. So what you have done, let's say you have limited space, the idea is to utilize those space as much as possible. School में pressy writing करते थे ना हम लोग, remember? We used to do pressy writing in our school. More or less the idea is same. We have to the approach has to be crystallized. And the meaning is that in less space and time, we have to highlight the most important points as far as possible. You start with you explain this, because in the introduction, if you see here, see the introduction again. Executive power with respect to subject matter in the concurrent list move away from the constitutional rule under Article 73 and 162, where executive powers of the Union and states are coextensive with the respective legislative powers. Now you have given a sort of a proposition. Next, you have to explain that proposition. You are saying that ठीक है, whatever is provided under 73 and 162, with respect to execution of those topic under concurrent list, it slightly moves away. What does it mean? It means where parliament has power to make laws and state also has power to make laws, then the parliament can ask the states, generally parliament asks the states to implement those laws. Okay. Explain. Then mention about how parliament asks the states to implement laws. Under list 3. So what it does, it ensures that the residuary power with respect to implementation of the laws under list 3, here I am talking about residuary power not from legislative purpose, from an executive purpose, क्योंकि demand of the question is executive aspect. Residuary power in terms of executing the laws, I'll write it, under list 3. See, use these words, generally is given to the state. But parliament can state otherwise also. It's up to the parliament. If possible, also mention about Article 256, 257, or even 258 for that matter of fact, because it talks about implementation of executive power. Then give some examples. That whatever you are saying, how will you justify it? So examples in terms of certain legislations which has been made on concurrent list by the center, but its execution has been left to the states. Conclude your answer. Good enough structure. Now you understand how to go ahead with it. Any doubts, please? See, I'm taking a lot of time on the first question because I'm setting the tone and also making you understand and realize that what is actually required. At the end of the day, no matter how you study, from where you study, does not matter. What notes you have referred, what you are writing on the piece of paper, what you are writing in the real exam, and how you are writing. Not just what you are writing, as I've said, how you are writing. So the content and structure both are important. But let's take it step by step. First of all, we understand the concept. Then try to structureize it. I've purposely taken these PYQs because it will remove your fear, nothing else. To address these questions, all you need is clarity, concept, and what else? Triple C's. Confidence that yes, you can. That's it. If you have clarity about a topic, obviously you will be writing. And if you talk about writing these answers, see, nothing can be learned in a day. It's a structured process. That's why these 20 classes, that's why these 20 tests, sectional test, full length test, all of that. All of it is a part of a structured process. You start writing smaller test. Once you complete the complete part, let's say section A pura ho gaya, comprising of constitutional law and admin law, then you write the sectional test. Similarly, you complete international law, write the sectional test. Once you complete both of it, you write the full length test. So in the process, again, what will happen? But you have to do it consistently. That is the point. No breaks, no excuses. Not with me, but with yourself, right? Do you agree with this? These three topics? Sorry, these three words? Chalo. Achha, I did not discuss the examples. These are some of the examples. I've just highlighted these examples. You see, Electricity Act enacted by Parliament under entry 38, list 3. I've just given it for your clarity. Now it's up to you how you write it as part of your answer. State governments are consulted to review and revise tariff policy and ensuring access to electricity in all areas. State Electricity Regulatory Commission can determine the tariff for generation, supply. So basically, states are involved in various ways. Essential Commodities Act enacted by Parliament under 1933. The whole of the power is vested in the central government, which however delegates power to the states. Land Acquisition Act, power is vested to the state governments to implement the provisions, particularly when land has to be acquired for public purpose. Right of Children, RTE, Free and Fair, sorry, Free and Compulsory Education Act. Can you tell me the constitutional provision based on which this law was, this parliamentary law was enacted? Correct, 21A. So what does 21A says? Till the age of 14, 6 to 14. Remember these minute details. These are important. Okay, chalo. So this part justify your ye wala example. Now it's up to you how you are able to adjust your answer in 2 pages since it was a 10 marker. Okay, and then of course we conclude. Any suggestion for conclusion? How shall we conclude? Say anything. Perfect. It strengthens cooperative federalism. Let's see what I have written here. Since I have highlighted the element of cooperative federalism earlier only, hence I am saying ki, but there are also laws on which Parliament enacts under concurrent list. It keeps the administration, implementation or execution to itself also. So uska bhi ek example ho gaya. So you have addressed as far as possible lot of parts. So what it says? Parliament may entrust administrative responsibilities to the Union on laws made under concurrent list. For example, central government has complete authority and responsibility to implement Forest Conservation Act 1980. It is primarily implemented and overseen by MOEF. Okay. Please ask your doubts. Any doubts if you have. What's your name? Ashutosh. Any doubts, Ashutosh? Since you joined late, you came late. Are you able to follow now what we are discussing? So have you taken the worksheet? Okay. Moving ahead. This was also asked last year. Just tell me what is being asked. Same. Let's start with the same process. It was claimed in the Constituent Assembly that the Constitution of India has in fact laid down a very facile procedure for the amendment of the Constitution. What is the meaning of the word facile? देखो डिक्शनरी में देखो, ऑनलाइन देखो, facile का मतलब क्या है? क्योंकि unless and until you understand a word, how will you be able to attempt it? See, what is bad? First of all, tell me what is facile. Because if you're not understanding facile, the whole part would be futile. Correct. Weak. Can I say that? Weak. So it says it was claimed in the Constituent Assembly that the Constitution of India has in fact laid down a very weak procedure for the amendment of the Constitution. Do you think the doctrine of basic structure significantly limits the amending powers under Article 368 elucidated? So this question has 2 parts. On one side, it is talking about certain observation made in the Constituent Assembly with respect to amendment or the process of amendment in the Constitution. And on the other hand, it talks about a very separate thing, namely Kesavananda Bharati judgment and of course the basic structure doctrine, right? Tell me the 2 individual components first and then how will we join them? Because there has to be a bridge. First we are talking about the debate which is taking place in Constituent Assembly, and then we are talking about the Kesavananda Bharati judgment. Kesava Nanda. Versus State of Kerala. Later on versus Union of India. Facts पता है केशव नंदा भारती के? It can be asked anytime. Please go through it. Chalo, we'll discuss that some other time. But tell me this first. So Constituent Assembly, it was claimed that the procedure is facile. Do you agree with this point? That the process to amend the Constitution as provided under the Constitution is facile or weak. Do you agree? भाई कॉन्स्टिट्यूएंट असेंबली की बात हो रही है, आप कहाँ इंदिरा गांधी पे आ गए? Constituent Assembly. Prior to Constitution, when Constitution was, let's say, debated, let's say whenever the provisions on Article 368 was debated when it was being made. You agree? Still it is facile? Chalo, I'll frame this question in a simple manner. Let's assume the Keshav Nanda Bharti judgment has not happened. मान लेते हैं, hypothetically, let's assume Keshav Nanda Bharti judgment does not exist. So what we are assuming hypothetically, that basic structure doctrine does not exist. Now tell me, forget about whatever judgments are there. Simply tell me, what does Article 368 talks about? Does it talk about substantive aspect of amending the Constitution or procedural aspect of amending the Constitution? वो सब interpretations थे गोलकनाथ ने जो भी बोला है, और whatever was said, you know, in the earlier judgments. But if you look at the marginal heading of Article 368, it talks about procedure also, and obviously it mentions about the procedure, right? Now see, what does article say? Article 368 says that to amend a constitution, what is required? A constitution amendment bill is required. Amendment bill is required, which can be introduced either in Lok Sabha or Rajya Sabha. Now this also means, which was clarified by the way in Keshav Nanda Bharti judgment, that a constitution amendment cannot be introduced through an executive order or through subordinate legislation. And hence the word law as explained under Article 13(3)(a), the word law has been explained or defined, which also includes executive order, ordinance, customs. This year's prelims question, right? ये पूछा था ना, ठीक है? So this law, what Keshav Nanda Bharti judgment finally decided, and this is what the interpretation still remains now, that the word law with respect to parliament, it means the power of parliament with respect to ordinary legislation. Let's say enacting a law, let's say Bharatiya Nyaya Sanhita, or any legislation, Patents Act, Trademark Act, koi bhi legislation, any legislation we are talking about, okay? So Keshav Nanda Bharti judgment very clearly said that when you are talking about constitution amendment, it cannot happen here. It cannot happen here. It also means, since the word law, if you go through the provision, it includes executive order, it includes regulations, rules, customs, etc. So very clearly, this confusion was clear that constitution, if there has to be a amendment of the constitution, that power is only given to the parliament under Article 368. Still you think it is facile? Not so. So Keshav Nanda Bharti judgment, even it was assumed to be facile, Keshav Nanda Bharti judgment provided that clarity. First, on this point, and obviously basic structure to hai hi, but this is one point which students generally do not talk about. If I ask you what was the essence, or what is still the essence of the basic structure doctrine, what would you say? Not what is basic structure doctrine, what is the essence or what is the impact of basic structure doctrine? ठीक है, philosophical note, anything particularly? Because here you are also talking with respect to power of parliament to make laws. Anything with respect to power of parliament, does it expand, limit, does it limits the amending power of the parliament. और ये amending power of the parliament article 368 में कैसा लिखा हुआ है? What does article 368 actually mention it as? It is what sort of a power? Constituent power. Go through the provisions, please. Also help you in your prelims. So this also is referred as constituent. कुछ common लग रहा है assembly और constituent में? Why the constituent assembly is called constituent assembly? Or rather, a basic question: why the Constitution of India is called the Constitution of India? This was also asked. Why a Constitution of India is called the Constitution of India? Correct. 393. It says this constitution may be called the Constitution of India. यही क्वेश्चन पूछा था ना, commencement of the constitution, whether it is written in the constitution or whether the constitution defines what is the commencement of the constitution. Yes, it defines under article 394, which would be 26 January 1950. And thus the Constitution of India repeals Government of India Act 1935 as well as Indian Independence Act 1947. Where? 395. All of this is provided. So, thus providing you clarity. So, this constituent power to amend the parliament is provided under article 368 and constitution cannot be amended here. Is this clear? And then obviously the process is provided. What is the type of amendment required? You have to write the complete thing which is provided there. Or what is special majority लिखोगे उतना effective नहीं होगा. So you simply just cannot write by special majority because there are different types of special majority. One special majority according to article 249. Now, how will an examiner understand what sort of special majority you are talking about? है ना? So you have to be very clear with these words. So tell me, what sort of amendment is required to pass a constitution amendment bill? Quickly. Correct. Total membership of the house. Because you have to write what is present or what is written in the constitution. Total membership of the house plus along with 2/3 of the members present and voting. Okay? You understand this, right? This majority is needed to amend a lot of other constitutional offices also, like judges of Supreme Court, CAG. Okay? Just keep that in mind. Okay. But it also provides another aspect, which says that ratification of half of the states will also be necessary. So in that sense, does it also provide, let's say, certain more stringent features whereby, which is necessary if those features of the constitution is to be amended, let's say, which can be categorized as federal features or those features which ensure center-state relationship or federal relationship. This question was asked last year. Extent of executive power of the state and union forms that part of it. So we see under article 368 itself, two types of amendment is provided if you have to amend the constitution. One is this, second is this plus state ratification by simple majority. So it's not that facile. And in fact, Kesav Nanda Bharati judgment further added more restrictions. So by categorizing certain features or certain points as basic structure, let's say these are the basic structure. Okay? This, all of these are basic structure. Now it also means parliament cannot amend it. So in a sense, it limits the amending powers of the parliament also. Now another issue with basic structure is that it's an open concept. And hence new concepts has been added. Let's say secularism by S.R. Bommai, appeal or power of High Court under Article 226 and 227 in the case of L. Chandra Kumar, which was also asked last year, by the way. You know? So new concepts have been added in this basic structure doctrine. So now if you look at this question after understanding our discussion now. Do you make sense of this question now? Two individual concepts, but there is a link. Kaise, how shall we attempt it? Tell me. I'll show you the introduction. I won't discuss the entirety of it because now you understand what it's talking about. So the amendment procedure under Article 368 cannot be said to be outright facile. See this word. This word is important. So you have to use those words which specify your point. Can we say that the moment you are writing or mentioning about this, directly you are addressing this part of the question? It cannot be said to be outright facile or simple. Certain provisions needs to be amended by special majority. I've written here, but explained later. And those features affecting federal balance requires an additional ratification by at least half of the state legislatures. So I've said, just as an introduction, that I do not agree with this statement. That itna bhi easy nahi hai. Can you also say that Constitution 44th Amendment further provided certain add-ons with respect to amendments? Kesavananda Bharati judgment, however, significantly restricted substantive amending powers of Parliament on subjects declared as basic structure. So just this following paragraph, I've tried to connect with the second part. Ki ye to already, it was not so easy. And now post this judgment, it is not at all that easy. Recently, just a fact, the government tried to introduce a constitution amendment bill, but it could not pass in the Lok Sabha. So that also means the government requires 2/3 majority. So not that easy, right? And then explain all these provisions. Restrictions provided in Article 368. Same point. Constitution amendment bill cannot be introduced to Article 13. Type of majority. See, I've highlighted exactly same point. Initially लिख दिया वैसे, क्योंकि I have to write something as part of the introduction. And then, thus, constitutional amendment cannot take place through an executive order of the government and must be done through a bill initiated in either house of the parliament. Here you can add Article 13 if you have that much of clarity. Matters which need state ratification. Most of these are features which affect center-state relationship or the power of the center. All of these. The manner of election of the president, extent of executive power of both union and states, high courts and union territories, goods and services tax, council, distribution of legislative, administrative and taxing powers. That's why GST bill required state ratification, because it amended the taxing powers of both center and states. Representation of states in parliament, amendment in Article 368. And once the requisite state legislatures have passed the constitutional amendment bill, then it is presented to the president for assent. Now coming to basic structure, restrictions on amending powers. I think this part is fairly straightforward. Okay? Yes, Parliament has power to, let's say, even amend fundamental right. And in this judgment only, Kesavananda Bharati highlighted that preamble is also part of the constitution, and hence the Parliament can amend preamble. But it cannot amend those points which reflects an aspects of basic structure. The court also held that laws made by Parliament can be categorized under same point. 368 wahi wala point. And Supreme Court held that Parliament has power to amend fundamental rights under Article 368 only if it does not affect the basic structure. So a question can be asked, let's say, does the Parliament has outright power to amend fundamental rights? Yes, it has. As long as it is not affecting the basic structure of the constitution. These are the basic structures. Simple. Added. These are added. Minerva Mills added the balance between fundamental rights and directive principles. Appeal from administrative and other tribunals to high courts under Article 226 and 227 added by L. Chandra Kumar. And then we conclude our answer. Therefore, Article 368 provides procedural clarity on the amendment of various provisions of the Constitution. Right? Evolution and expansion of basic structure doctrine has expanded the scope of judicial review for constitutional amendments if they violate basic structure of the Constitution of India, because ultimately that power is with the judiciary. Whether it has happened or not, no one, Parliament cannot outrightly say, or an individual, let's say, whose fundamental, or a person whose fundamental right is affected, they cannot say. Ultimately, it has to be decided by the courts. So if I get back to this question, I would need from you, yahin pe bata do, just give me a structure here. We have discussed the entire question. Just give me the structure. Do you think whatever we are discussing helps you in certain way? Tell me the structure. That's it. अरे अभी तो डिस्कस कर लिया. So that's what I'm asking you again. ठीक है? Correct. So you have to link the element of constituent assembly, whether it is facile or not, and what has Kesav Nanda Bharti judgment, this judgment did to the amending powers. Then explain in detail the procedure with respect to Article 368, and also say effectively that Article 13 wala aspect. ठीक है? So lay down the procedure plus state ratification points. Obviously followed by how basic structure limits amending powers of the parliament, and then you conclude your answer. Conclude by highlighting an element of judicial review. So try to, as far as possible, हर वक्त नहीं हो पाएगा, but as far as possible, try to add a new element in the conclusion also. That can be, let's say, a current development. That can be, let's say, any case law. That can be, let's say, any legislation or any new term. You can do that. So again, this you will learn through successive practices. Shall we move ahead? Taking another question on, I think this is on judicial review. Explain and elucidate the grounds of judicial review for administrative action by quoting decided cases on the subject asked in 2023. Acha, based on these two questions, or based on that question, on the first question, a question was also asked by UPSC that between center state distribution of powers, the slant is in favor of center. What does it mean? If I say between center state relationship, let's say legislative and administrative relationship, the slant is in favor of center. क्या मतलब है इसका? What does this statement exactly mean? Correct. Absolutely. Residuary powers, repugnancy, 254, that in first instance, preference is given to the parliament, then state को मिल सकता है provided the precedent extends, but still parliament has power to override that state assent. And in administrative relationship, we have already seen 256, 257, 258, and all of these provisions, we see that yes, with respect to the center-state relationship, the slant definitely is in or towards center. Now, will you able to attempt such questions? Grounds of judicial review for administrative action. This has a link with constitutional law. Can you tell me how? I'll give an example. Through Article 13(3)(a), which particularly defines the word law, and through the powers of, obviously, judicial review, both of Supreme Court and High Court, this under Article 32, and this under Article 226. Now tell me, can you see the constitutional connection here? But when we talk about judicial review for administrative action, why particularly are we talking about for administrative action? Now this is also part of your syllabus under administrative law. And see, very straightforward question asked in the year 2023. Last two questions we discussed, asked last year. This question is from 2023. Okay? Straightforward question or difficult question? Straightforward question. I don't think इसमें कुछ explain करने की बात है. But tell me, what is the meaning of this judicial review of administrative action, and how is it different, particularly with respect to powers of judicial review of the High Court? I am making a statement. Tell me if I am wrong. This power of judicial review for administrative action High Court has greater power as compared to Supreme Court. Am I correct? Am I incorrect? Why? Correct. Correct. 32 can be invoked only when you say fundamental right under Part 3 has been violated. But High Court under Article 226 has greater power. So violation of any aspects of Part 3 plus any other legal right. And the moment we talk about any other legal right, it also includes, let's say, violation of principles of natural justice or violation of any right, legal right of any person. And that violation of legal right can take place through any of the administrative action. Since the word law also includes executive order, rules, let's say regulations, or the power of subordinate legislation, which are expressed through rules and regulation. So any of these, if it violates fundamental rights or any other rights, obviously high courts have greater power, and generally various writs can be issued. Can you tell me one writ? Generally I'm saying one writ which is mostly used in cases of violation of judicial review for administrative action. So सबसे ज़्यादा use होता है. I'm not saying कि other writs are not used. I'm not saying that. But one writ which is also asked by UPSC. Certiorari. A question is asked that explain the importance of the writ of certiorari with respect to judicial review for administrative action. एक ही है, कोई अलग क्वेश्चन नहीं है, because certiorari is issued when the authority lacks jurisdiction, or let's say when the authority has given an order which violates principles of natural justice, which is, let's say, which they do not have any power. Okay, so any of that. Okay, so this is also asked. So again, how shall we introduce this? So what should be the structure? Tell me. I don't think I need to explain this in detail. Just tell me the structure here. I think this should be straightforward. So address, introduction में क्या लिखना चाहिए? Tell me. How is this judicial review exercised? By high courts and supreme courts? Write this. Respectively, but also write that high courts has greater powers. Write this part. Then lay down the grounds. Tell me the grounds. Violation of PNJ, lack of jurisdiction, colorable legislation, dictation, Westbury unreasonableness, all of that. Highlight all those elements of, see this. Considering the ever expanding and complex decision making by executive authorities, judicial review over their actions becomes imperative, as it not only keeps the administrative authorities within their jurisdictional limits, but also safeguards rights of citizens from arbitrary decision making. So in the in the introduction, you not only highlight about high court powers, but also why it is important. It keeps them in check and also address the FR violations. Then very simply, when let's say they have exercised or they have taken any decision which they do not have, or which legally they are not empowered to, lack of jurisdiction or excess of jurisdiction. See this is very important one. Rafiq Khan versus State of UP. Panchayati Raj Act did not empower the subdivisional magistrate to modify the order of conviction and sentence by Panchayat Adalat. He could either quash the entire order or cancel the jurisdiction of the Adalat. But what he could not do, he could not modify the judgment or the award of the Panchayat Adalat. He did exactly the same. Obviously, it's a thing which you have not been bestowed through law. You cannot do it. Excess of jurisdiction, J.K. Chaudhary versus Datta Gupta. Governing body of a college affiliated to Guwahati University dismissed its principal. Court issued certiorari to quash action on grounds of excessive jurisdiction. Generally, it is seen these grounds of judicial review, again I'm saying generally, and the grounds to issue certiorari generally are similar. Error apparent on the face of record means it is very clear, it is visible, that error is visible. Supreme Court explained that there would be a case of error of law apparent on the face of record where conclusion of law recorded by an inferior tribunal is based on obvious misinterpretation of the relevant law, or let's say it's per incurium. They have gone beyond their scope, or in ignorance or disregard of the law. They have not considered legal aspects. ऐसे ही judgment दे दिया. Wensbury unreasonableness. While defining irrationality, Lord Diplock equated it with Wensbury unreasonableness, which was developed in Associated Picture House versus Wensbury Corporation. Basically, do you know this case? Any idea? Certain restrictions were issued that some people of certain age cannot see, and this is not to be movie cannot be shown on, let's say, certain days, and hence it was said that it's basically unreasonable. So that's the idea. What it means that administrative discretion should be exercised reasonably. Accordingly, a person entrusted with discretion must direct himself properly in law. He must call his attention to matters which is bound to consider. He must exclude from his consideration matters which are irrelevant, and if he does not obey those rules, he can be said to acting unreasonably. Now, administrative authorities are generally given certain discretionary powers. So, the law does not, or the subordinate legislation or the executive order does not define it. But discretionary power does not mean that that officer or that authority will act in an arbitrary manner. How will we say a person is acting in an arbitrary manner? When he is not following the rules, when he is violating the principles of natural justice. Let's say he is not giving an opportunity to the other person to be heard, right? Or he is going beyond his statutory mandate to decide any case or take any decision which has affected the rights of the person or rights of any individual. Okay. Proportionality. Are you aware about the concept of proportionality? In general, what is proportionality? Proportionality or a point was also highlighted in the famous judgment of K.S. Puttaswamy. Right to privacy. See, all these are important. You should know. Right to privacy is part of Article 21, right? Right to privacy is part of now Article 21. But like any other fundamental right, this is not absolute. And state can regulate privacy if it so wants. And what are the grounds on which state can regulate privacy? If there is a law, so on grounds of legality. If there is a need to regulate such privacy, let's say to ensure national security, and on grounds of proportionality. These are the three reasonable restrictions which a state can impose to restrict right of privacy according to K.S. Puttaswamy judgment, which was a unanimous judgment, by the way. Means all the judges gave the same opinion. Now, proportionality simply means let's say the authority has three options to take a decision. उसके पास तीन तरीका है. He can take a decision, let's say, through process A, through process B, and through process C. So principle of proportionality says he should choose that process which is least restrictive, which least limits the rights of the citizens. Let's say option B is the least restrictive rights, and option A, if the authority takes action A, then this is the max. This here the right will be limited to the maximum extent, and at process B rights will be limited to the least extent. So the doctrine of proportionality says that B should be chosen. Even while taking administrative or discretionary decision, this proportionality should be followed. Now you are clear with concept of proportionality. What is double proportionality? जान लो. Question आया है, question can be asked, and this is often used in judgments. Electoral bond case में Justice Chandrachud highlighted this concept. Simply just remember as of now that if two fundamental rights stand opposed to one another, let's say Article 19(1)(a) stand opposed to Article 21. So which will be given priority? Let's say two fundamental rights conflict one another. Electoral bond case is the perfect example, because if you disclose the name, let's say, then whose right you are fulfilling? Freedom of speech. But if you do not disclose that name, and if you want to guard it, guard the privacy, Article 21, Supreme Court weight the two rights, and all, again proportionality यहाँ भी लगा एक तरह से कि which of them, not in terms of least restrictive, but which is most beneficial in terms of public welfare. So what was the criteria here? Public welfare in a democracy. Okay. Which was chosen among these two? Court chose which of them? 19(1). Correct. All of these are part of proportionality. Principle of proportionality implies that court has to necessarily go into the advantages and disadvantages of the action called into question. Let's say the authority took process A, then they have to see na ki if they took process A and process B was available, why they did not take it. So it becomes very subjective. But these are the stages. Legitimate, well, whatever the process was taken, let's say it was whether it was to achieve a legitimate goal, suitability or rationality of that step taken, necessity, same. See, balancing state, sufficient safeguards were addressed or violated. All of these. Then legitimate expectation. Legitimate expectation under administrative law means, let's say if a certain process has been established, then the people start following that process. Let's say if license is to be provided, and lottery system is one of the process which the government has followed over the past, then that is the step which has been followed over the past. So it says this doctrine serves as a ground of judicial review to protect the interest when a public authority does not follow a well-established process. Now RP Singh versus State of Bihar, here the courts explain this point. So it says established practice referred to a regular, consistent, predictable and certain conduct or process or activity of the decision-making authority. An expectation should be legitimate, that is logical, reasonable and valid. So let's say in allotting houses to the vulnerable section, if certain process has been followed and suddenly the government changed the process, then that change in process can be questioned on the ground of legitimate expectation. Judicial review or excessive delegation. So means delegation is allowed, but not excessively. So there has to be a limitation on delegating power, highlighted in the case of Hamdard Dawakhana. So, and abuse of discretionary powers. See, we have discussed discretionary powers are there given to authorities, but its abuse can be challenged. If it is malified, I don't think I need to explain this. And it obviously it violates person's rights. If it operates on bias, malice or bad faith. Colorable exercise of power. If power of detention is used as a substitute for criminal prosecution, clearly it's a colorable exercise of doing something in a guise which you are not allowed to do. And acting under dictation means you're not applying your mind, simply you're following orders of the senior. Conclusion, thus judicial control over administrative action by use of prerogative writs and declaring administrative action as ultra vires has ensured administrative decision making follows rule of law and principles of natural justice. What is the meaning of rule of law? What is the importance of rule of law? Yes, it ensures that no decision is taken in a discretionary manner. or in an arbitrary manner. मन मर्जी थोड़ी है. Let's say an authority has to decide a matter. Either there are judgments, either he's bound by certain regulations, executive order, or let's say he's functioning under the ministry. अब Ministry of Environment, Commerce Ministry का तो decision नहीं लेगा. So somewhere their functionalities have been assigned. That is the meaning of rule of law. Okay. Okay. I think I've discussed enough questions on constitutional law, taken a lot of time, more than what I anticipated. Let's move on to international law. This question again was asked last year. If I may ask you, all of you here, how is your international law? Do you think you have studied it properly, or you need more guidance or help? Okay, all of you agree? ठीक है. Tell me from which part of the syllabus this question has been asked. ठीक है. What else? To यहाँ पे दो चैप्टर को मर्ज किया गया है. See, is anticipatory and preemptive use of force for self-defense permissible under Article 51 of the UN Charter? To give you certain more backdrop here, just understand this, certain basics, okay? What is the purpose of the United Nations? What is its basic purpose? ठीक है. For what purpose? Why was UN established? Why was UN established? After 1945, no? Or in 1945, 24th October. The idea was to stop the brutalities of the world which they had seen at that point of time, and hence to ensure peace and stability. So purpose क्या है इसका? To ensure, let's say, global peace and security. Can we say this? See, few provisions of UN Charter is very important, and accordingly we established, or a United Nations Charter was established, which provided for various principles. ठीक है? UN Charter. So if this Charter or the United Nations as an institution was established to ensure global peace and security, will it justify use of force? Or will it justify war? In certain situations. So we need to know those certain situations very clearly. So as far as UN Charter is concerned, two provisions, Article 2, Clause 4. It, in simple terms, it prohibits use of force. It prohibits use of force. And Article 51, it says that certain countries may use force as a form of self-defense. May use force as a form of self-defense only if an armed attack has taken. So let's say between A and B, B can only use force as a form of self-defense only if A attacks B. Okay? And that attack is not a normal attack, but what type of an attack? Armed attack. So the threshold of armed attack is quite high. Okay? So what it says, B can retaliate, in simple terms, B can retaliate on A, but for that A should have attacked B first. Okay? And only then this retaliation in that sense is justified even under international law. And that retaliation will be then said to be a retaliation in self-defense. Clear? And when, let's say, B takes this step as an attack or in a form of self-defense, intervention in the form of self-defense, not intervention, let's say a retaliation in the form of self-defense, then as per Article 51, it must inform United Nations Security Council. But criteria क्या है? what should have happened? Sorry. Armed attack should have happened. Okay. But now this question is talking about something else. This question is talking about anticipatory or preemptive use of force. Mean, same example, that between A and B, now A has not attacked B so far. A ने attack नहीं किया है. A has not attacked B. But B anticipates that A could attack B at any time. Let's say B has certain information from their intelligent operatives, from their military or from naval intelligence. They have certain information that A is likely to attack B. So on ground, has A attacked B? No. So B anticipates an attack from A. And in this anticipation, and as a form of retaliation, B attacks A, justifying anticipatory or preemptive use of force, again as a form of self-defense. Do you understand the difference here? Now look at the question. Is anticipatory and preemptive use of force for self-defense permissible under Article 51 of the UN Charter? Discuss. So to know whether it is permissible or not, obviously you have to know all these fine details. Do you understand how UPSC is framing question? So it is this question, you cannot say that this is a very superficial question. Now you have to have that clarity. You have to know a very important aspect of anticipatory self-defense is that this is a part of customary international law and justified, or this is based on a very famous case of Caroline case between USA and UK. Canada and UK. Ultimately, the exchange took place between UK and USA. But they attacked the Canadian ship. True. Britain attacked the Canadian ship. So this concept, first of all, does Article 51 of the UN Charter mention specifically of preemptive or anticipatory self-defense? The answer is no. It does not outrightly say so. So we have to be very diplomatic. And then we have to take help of various judgments of the International Court of Justice, that what has been their opinion. And we see that this is somewhere a gray area of debate. Because based on this Caroline formulation, or since this concept is justified as a part of customary international law and hence obviously part of international law, so it is justified. US has taken a lot of decisions, or US attacked some states as a part of anticipatory self-defense, justifying or based on the Caroline formulation. So you can say that this concept operates outside the treaty provision through the customary international law. Is this point clear? So basically, this combines two chapters of use of force and aggression, which is one part of the syllabus, and obviously the United Nations and its charter. ये दोनों को combine करके ये question पूछा गया है. So at times UPSC does that. Okay. Just look at the introduction. Rest you can understand. Article 51 does not specifically mention about anticipatory and preemptive use of force for self-defense, and hence its use under the UN Charter can be debated. However, anticipatory and preemptive use of force can be traced to the Caroline case as part of. So in the introduction itself, you have addressed the basic demand of the question. And then from here on, obviously, you explain about the Caroline case, what was decided, how on Caroline case we can say, based on the Caroline interactions which took place between United States and UK, how can we say that yes, this element of preemptive or anticipatory self-defense becomes part of customary international law, and when it can be said to be justified? See this. Oh, sorry. Okay. I've just explained exactly what happened. So traditional definition of this concept can be found in customary international law, arose due to Caroline case. The dispute revolt around an incident in 1837 in which British subjects seized and destroyed a vessel in American port which was used in support of Canadian Revolution. And hence ultimately it became a basically US-UK thing. So the correspondence took place then, that how do we determine that when force can be used? See, the US Secretary of State laid down these following essentials of self-defense: necessity and proportionality, the point where we started our discussion. There had to exist unnecessary of self-defense, instant, overwhelming, and leaving no choice or means and no moment for deliberation. Coming to this example of anticipatory self-defense where B has not been attacked, but B gets to know that A is about to attack B. Now consider this concept, anticipatory self-defense, from the perspective of, new technologies, particularly with respect to warheads, including nuclear arsenals. Because let's say if A is actually about to attack B and the attack will take 10 or 15 minutes, then what is B supposed to do? Suppose A ne actually mein missile, the missile, it's a ballistic missile, it goes into the atmosphere and it will take around 15 to 16 minutes to hit B. So B has, let's assume clinically, 12 minutes to respond. And B knows that 12 minutes mein mere pe attack hoga, based on the precision of these missiles, considering the advancement in technology. So considering all these aspects, the use of anticipatory self-defense or use of force has become actually quite debatable, as we are already witnessing in the ongoing conflict in US and Iran, right? So yes, if this happens hypothetically, then B, do you think B has a right then to attack in a form of self-defense? So let's say it's not a nuclear warhead, but B in a retaliation as a nuclear warhead. Would that be proportionate? No. So this is what it says. It should follow the principle of necessity and proportionality. Very difficult to implement in reality. Okay. The action taken in pursuance of self-defense must not be unreasonable or excessive, since the act justified by the necessity of self-defense must be limited by that necessity. One more thing, which although it is not highlighted here, but will also come into picture, is the international humanitarian laws or the laws of the warfare. That while using, let's say, any warheads, again, same principle of necessity and proportionality has to be highlighted. But how to ensure that, right? It's very difficult to ensure, and one of the basic or the core principles of laws of warfare or international humanitarian law is that combatants and non-combatants there has to be a clear bifurcation between combatants and non-combatants. And non-combatants, or you let's say civilians, they should not be attacked at any cost. And as of now, we can definitely say that throughout the world there is a violation of international law going on. Generally, है ना? So ये question आ सकता है कि despite this core principle of international humanitarian law, that is difference between combatant and non-combatants, that is civilians not to be attacked, yet it is not been followed in its true essence or spirit. Examine. So obviously there we have to highlight, we have to address the answers based on the legal provisions, but keeping the realities in mind. I'm sure you're going through the newspapers as part of your GS also. It gives you that advantage that you can quote, let's say, some example, but we have to keep our answer very strictly to the legal points. Okay. So these principles were accepted by the British government, and they became the norm, established norm, whereby attack can take place on grounds of anticipatory self-defense. But the problem does not end here. The problem is that even ICJ in all these decisions has clearly said that yes, attack as a form of self-defense is possible only when armed attack has taken place. So even ICJ has not very clearly mentioned it, whether it is justified or when it can be done. So obviously it still remains as part of a gray area, but definitely it has been understood to be part of customary international law, that is for sure. So Chatham House principles, it's basically one of the important, you can say, institution which provides important principles on international law. On the use of force by states in self-defense states that there is a risk of abuse of doctrine of anticipatory self-defense, and it needs to be applied in good faith and on the basis of sound evidence. Again, very difficult. But are you clear with this concept of anticipatory self-defense? Structurization of the answer also. Oh, sorry. I think वो change नहीं होगा. Conclusion. Vienna Convention. Are you aware about Vienna Convention? So what does it talk about, Vienna Convention? Correct. Few things, I'll just explain you some basics. When we talk about sources of international law, then there are 4 sources. International treaties. Now, international treaties can be, let's say, between 2 countries. International treaty could be, let's say, between a country and an organization. Let's say India and World Bank. Possible? Or UNESCO, or any other institution, United Nations Environment Program, UNEP. Then we have, as I've told you, customary international law. Then we have general principles of law. So what are those general principles of law? General principles of law are ये दोनों के बाद जो gap बच गया, whatever the gap remained post treaties and customary international law is generally filled by general principles of law. For example, equity, good conscience, prescription, res judicata, which is generally applied either in a municipal law or as a part of international best practices. And then the 4th one is actually 2. Decision of courts, let's say ICJ, and एक ही आता है opinion of scholars. This part is referred as primary source of law. This part is referred as secondary source of law. क्यों है? We'll discuss all of that later. In fact, this is subsidiary means to determine the source of law. That's the correct word. Subsidiary means to determine source of law. Now these international treaties between states. Now when I say the word states, it is sovereign countries under international law. This is how states are referred under international law. So when 2 states enter into a treaty, it is guided by a treaty known as Vienna Convention on the Law of the Treaties, referred generally as VCLT, 1969. Okay? This Vienna Convention on the Law of the Treaties define the word treaty. That what is the meaning of the word treaty? I'm sure you have heard this word convention, covenant, agreement. They all are same. It does not matter. The designation does not matter. Whatever it is called, it does not matter. As long as 2 countries enter into a bilateral or a multilateral treaty, if that treaty is in a written format. and agreed upon, obviously, between the parties. So this international treaty is based on consent of the states. Like whether it agrees or not, it's upon India. Whether we want to be part of international treaty or not, it's our sovereign decision. Similarly, it's a sovereign decision of all the countries. So Vienna Convention on the Law of the Treaty, which we also have to study separately as part of Law of the Treaties, this provides for a concept known as reservation under section 2 of part 2. Now you'll ask me, what is reservation? Let's say this is a treaty. Suppose ये कोई treaty है. Suppose this is a treaty on law of the sea. Okay? And India is also party to the treaty. But India says that, see, I'm fine with the treaty, but I have problem with this part of the treaty and I do not wish to follow it. So this is the meaning of the word reservation. So when reservation can be made, let's say, what is the process of treaty making? When there is negotiation stage, when India is trying to negotiate the terms of the treaty, or when India is, let's say, at the time of signing the treaty, let's say at the time of accepting the treaty or ratifying the treaty, let's say. So at any point of time, any country can say that certain provisions of the treaty, its legal effect will not impact them. So when we say any country makes a reservation with respect to certain provision of the treaty, then it means that those part of the treaty will not apply to that country. Is this clear? So अगर इंडिया बोलता है कोई इंटरनेशनल ट्रीटी में कि we make reservation on, let's say, Article 19, 20 and 21 of this treaty. So it means Article 19, 20 and 21 of the treaty will not be applicable to India or any other country if it claims reservation. This is a basic simple meaning of reservation. So if you look at the introduction, see what it says. Vienna Convention on the Law of the Treaties 1969. Under section 2 and part 2, from, I've highlighted the provisions 19 to 23, has defined reservation as a unilateral statement. So a country is saying by themselves, made by a state while signing, ratifying, accepting, approving or acceding to a treaty. So when it can be done? While doing all of these, whereby it seeks to exclude or modify the legal effect of certain provisions. So what is the impact of reservation? It modifies or exclude the legal effect. Means this part of the treaty, anything, then we have to understand based on the implications or based on any claim made by any other country. So let's say this treaty says reservation cannot be made on its initial 3 articles. Article 1, 2 and 3 पे आप reservation नहीं ले सकते. So no country can claim reservation on that because it defeats the purpose of the treaty. Let's say the treaty is to determine the boundaries of continental shelf, and you are saying that the method by which these boundaries will be determined, I do not want to follow it. Then don't participate in the treaty. So there are certain international treaties whose entirety reservation you cannot make. So it depends. It depends from treaty to treaty. It depends from country to country. Let's say this international treaty has 20 countries participating in it, and 2 countries claims reservation on certain provision. It can be contested by other countries. It cannot be contested by other countries. Other country says, okay, fine, it's okay, as long as it is not affecting the core part of the treaty. So generally the understanding is that on a core part of the treaty, reservation, clear? Exactly, this is what you have to explain. What is the meaning? Capacity of sovereign state to make reservations to an international treaty illustrates the principle of sovereignty of states. I do not want to follow certain part of the treaty, right? Whereby a state may refuse its consent to particular provision. Generally, a multilateral treaty ensures harmony and level playing field as different countries. So mostly in a multilateral treaty, there are certain provisions allowed in terms of to ensure that yes, treaty actually it's ratified. So reservation therefore allows concentrating on the most important agreed provisions along with accepting reservation or disagreement on certain points. Let's say there is agreement on 70 or 75% of the treaty, of the provisions of the treaty. This is fine, chalo. At least let's implement it. So reservation enables state to accept a multilateral treaty as a whole by giving it the possibility not to apply certain provisions. So this is the meaning of the treaty. I'm simply explaining you what is the meaning of reservation, and of course what is the impact of reservation. This is what has been asked. If we go back to the question, see, discuss the right of state parties to formulate reservation to a treaty under Vienna Convention of Law of the Treaties. Again asked last year. So far we have discussed, this is the 5th question. What is your opinion on the type of question which is UPSC is asking? What do you think? What you need to do? Different? Why? Syllabus subjects are same. Forget about international law. चलो constitutional law पे बात करते हैं. Sure. Sure. Correct. Yeah, syllabus is same. Law is same. Constitution does not change. International law does not change. Approach changes. True. Correct. Absolutely. But do you all agree on this point, whether it's analytical or not? At least it starts with the very basic thing of knowing the topic. ठीक है, मतलब ठीक है, एनालिटिकल है, बेसिक स्ट्रक्चर में एनालिटिकल हो सकता है, या you know, part of contract law may be analytical, but we have to know now what is, let's say, what is a void contract, or when contract can become voidable on either of the sides. So what I will suggest, and this is my understanding, is that you have, again, it's a three-step process according to me. Even for those appearing for this year's mains, the idea is to understand the concept. On that topic, let's say the topic is treaties, international treaties. So you have to see, based on the previous year's questions, what sort of questions have been asked. At least this will give you an idea what to study, of course. What are the dimensions which UPSC has touched on that question? Let's say on international treaty, question is asked on, let's say, reservation, termination of a treaty, what is a declaration, or any other aspects of an international treaty. Okay? So these previous year's questions, 10 to 15 years, let's say if you go through on any given topic, it gives you that idea. And the purpose is not just to, you know, mug up the topics, but to also to understand why UPSC is asking those points and how do we actually address those issues. And that's the reason why I have taken PYQs directly, because I know all of you are law graduates, right? All of you are law graduates, and you have studied this in some way or the other. Maybe not like this, but at least you know the basics. You know constitutional law, you know administrative law, you know elements of criminal law. But here, I'm trying to show you the real picture. Okay, this is the reality. As in, no, there is no fakeness about it. You cannot say that this is what we need to, because this is what is actually required. And people are clearing it. It means they have that kind of clarity. All you need to develop is that kind of clarity. And of course, when you have that clarity, you have the concept, you understand, then start writing. As soon as you start writing, that is, you know, when you actually becomes, you know, you can say part of the race, है ना? क्योंकि जब तक आप लिख ही नहीं रहे हो तो फिर it doesn't make any sense. Okay, चलो. Shall we move ahead? Okay. Then Article 19, the provisions. Basically, then you go through the provisions, highlight the provisions. A state may, while same point, ratifying, accepting, approving, or acceding to a treaty, formulate reservation, unless reservation is prohibited by the treaty. Treaty provides that only specified reservations be made. See, I have explained you in very simple way all aspects. Everything is written in the provision itself. So, for example, reservation is incompatible with the object and purpose of a treaty, such as Convention on the Elimination of All Forms of Discrimination does not allow reservation that conflict with its core aim. Similarly, भाई कोई अगर treaty अपने core aspect पे क्यों allow करेगा reservation? फिर तो it doesn't make any sense ना, you becoming part of that treaty. Let's say India says we are party to the Treaty on United Nations against corruption, and then we say, nee, we do not want to make a law on corruption. It does not make any sense. Any law which India has made on to tackle corruption? Prevention of Corruption Act, Lokpal Act. Yeah. Whenever you go through any legislation, ना, तो legislation का ना जो preamble होता है, जो first part होता है, when you go through it, generally we do not study that. So it mentions that which international convention India has ratified, and based on that we have made our laws. So if I ask you, is India party to WTO? Okay. So if India is party to a WTO, or if India is party to any international agreement, how does it affect our national legislations? Let's say this very simple question is asked, that when India becomes a party to a international treaty, how does it impact our national legislation? It's a very generic question asked under international law. Explain with the help of examples. Explain with the help of illustrations. Basically, this question is trying to ask that how India implements, when India, let's say, ratifies WTO. Suppose India ने WTO ratify कर लिया. अब क्या India ratifying WTO itself becomes part of Indian laws? So here the question is based on the concept of dualism. Remember, we studied this in college, monism and dualism. This is what you have to write. But the question is not asking you very directly. What it मतलब कि आपको ये लिखना है. What it is asking, how India implements the international treaty as part of the national law. Any constitutional provisions which comes into mind? Correct. Whereby Parliament can make legislation. So whenever you go through, particularly let's say laws on environment, वहाँ आप देखना start में ही legislation के, even under Lokpal and Lokayukt Act, this is written. Okay. Just telling you, giving you all the important observations. And Article 20 says reservation expressly authorized by treaty does not require any subsequent acceptance. And then obviously just the important highlights of Article 19, 20, 21, 23. It will depend on how much marks the question is. But in essence, you have to explain the meaning of reservation. The answer should not be mere mechanical. Article 19 says so, 20 says so, but it means that the essence of your answer, the examiner cannot make out. So it says, Article 12 of Geneva, for example, Article 12 of Geneva Convention on Continental Shelf provides that at the time of signature, ratification or accession, any state may make reservation to articles of the convention other than Article 1 to 3 inclusive. Very clearly. So it means any country who was party to the Geneva Convention on Continental Shelf could not make any reservation on the first 3 articles. Same point we discussed, no? Most climate change treaties, including UNFCCC and Kyoto Protocol, prohibit making of any reservation. UNFCCC, Article 24, no reservations may be made to this convention. Kyoto Protocol, no reservations. So it depends. So you have to understand the basics. You have to then express the meaning and give examples as long as possible. And if you remember the correct provisions, then please highlight. Legal effect of the reservation, I think, which we have already discussed. And then we case laws in legality on the use of nuclear force. It was highlighted that effect of a reservation is simply to exclude the provision of the treaty, same point, to which a country intends to apply. Reservation to the Genocide Convention case. So it says in its advisory opinion, ICJ held, as requested by UNGA, after some states had made reservation to the 1948 Genocide Convention. Ab is pe bhi reservation bana raha hai. What did ICJ say? Court observed that a state which has made and maintained a reservation, which has been objected by one or more parties to the convention, but not by others, can be regarded as being party to the convention if the reservation is compatible with the object and purpose of the treaty. But let's say if someone wants to make a reservation again on the same core part of the treaty, which contradicts the implementation of the important aspects of the treaty, it does not make sense. And then again, states can raise their concerns with respect to such reservation. Vandenberg reservation, as a conclusion, I've added a new point. Vandenberg reservation is generally made to a you can say, when a treaty is a multilateral treaties, basically. let's say UN. Basically what happened, United States of America in a particular case claimed this Vandenberg reservation against the UN Charter itself, some of the provisions of UN Charter itself. So court did say that ठीक है, it's possible that Article 51 of the UN Charter will not apply to you, or let's say any other provision of the UN Charter will not apply to you. But और क्या क्या था sources of law? Court said that whatever is mentioned under Article 51 with respect to use of force as a part of in self-defense is also part of, and customary international law exists independently of treaty law. It's possible that certain provisions of customary international law is codified. Even if it is codified, let's say it is converted into an international treaty, even if it is converted into an international treaty, still the existence of customary international law does not end. Remember this. So Vandenberg reservation, which is also called multilateral treaty reservation, refers to a reservation expressed by any member state when signing, ratifying, acceding to a treaty, and it generally express exclusion from the jurisdiction of international court. So why did USA claim this particular Vandenberg reservation? क्योंकि वो कहना चाह रहा था कि आपको jurisdiction ही नहीं है ये case decide करने का. But court was smarter. Court said, yes, I have jurisdiction. Yes, you can claim Vandenberg reservation with respect to treaty law, but I have jurisdiction to decide a matter through customary international law. And where all these points have been provided, where these sources of international law has been provided? Correct. Absolutely correct. So remember these important points. Article 38 of Statute of International Court of Justice. Do you think this is an important point? You can highlight it, let's say, anywhere while explaining a point on treaty or customary international law or general principles of law. Another important topic asked last year is this. Tell me, what do you understand by this? Explain the principles of most favored nation and national treatment in the international trade law. Is it permissible for a WTO member state to impose different rates of reciprocal tariffs on other member states of WTO? Can a member state affected by the higher tariffs Can a member state affected by higher tariffs file a complaint with the dispute settlement body of WTO? Discuss. Do you think this question, when it was asked last year and there was a tariff war going on, do you think it's a result of this? यही मैं बोलना चाह रहा था आप लोग को पहले कि if any international development is taking place, we'll try to discuss as much as possible. So this is just one example of it. Yes, trade war was taking place. US started it with respect to these reciprocal tariffs. And very simple question has been asked, although it is a बहुत लंबा दिख रहा है, but if you understand the basic, again, if you understand the essence of these questions, it becomes much easier. What is the essence of international trade law? Correct. उसको और अच्छे वे में हम कैसे बोल सकते हैं? You're right. You're on the right direction. Actually, you know what is provided in the syllabus? Syllabus में लिखा क्या है? Any idea? Any of you? नहीं, ये नहीं लिखा है. It says new international economic order and many other things. New international, NIEO, new international economic order. Now, what is this new international economic order? When was it achieved? When was it highlighted? When we talk about new international economic order, the whole concern started, the concern on the very basic level is the same concern which we also discuss under environment law. And the concern is the difference between developed, I'm giving you just the backdrop, developed and developing, or let's say least developed countries. ठीक है. Can we call them global north, or do we call them global north? This is what you study under environment law also, right? We call them global south. Do you think they are more developed? What is the meaning of this? They have greater access. Do you agree? All of this they lack. Suppose कोई एक example लेते हैं, कोई African country लेते हैं, any other country which falls under the global south. Let's say that country has ores. It has ores of iron and gold, but it lacks technological machineries or prowess to extract gold. कहाँ से आएगा? यहाँ से आएगा. यहाँ के कोई कंपनी वहाँ जाके उसको करेंगे. And this is what has started. So these developing countries of the global south saw that they were being misutilized. Their resources were being misutilized, and these developed countries did not want to ensure parity with them. When United Nations organization was established in 1945, so it provided, can we say it provided political sovereignty to all member states by ensuring one vote under UNGA. On the same concept, what was envisaged actually was international trade law or international trade order. And on the same idea that all countries will have one vote. Obviously, they did not like it. They wanted control over their resources, over their finance, over their technology. Still they have. Can I say? Through this, they control certain aspects of financial activities. Okay. So this was this element of the problem of the concerns of developing countries. They raised this concern in the UNGA through UNCTAD, United Nations Conference on Trade and Development. And UNGA passed various resolutions and addressed or recognized the problem of or the issues pertaining to new international economic order. Okay? And what was envisaged to be established as an international institution for trade law, the whole purpose was to ensure that no discrimination takes place between either of these. So there is parity in terms of trade. क्या purpose था कि discrimination नहीं होना चाहिए. There should be no discrimination. But it could not materialize, and slowly through various rounds of discussion, what actually was materialized was WTO in 1995. 1st Jan 1995. Again with the same concept of there should not be any discrimination in trade, the point which you were saying. Correct? अब उसका एक point है, the principles of most favored nation and national treatment. Are you aware with this concept? What is it? Correct. Correct. If you are giving any immunity, any privilege, any preference, so let's say if you are giving any immunity, privilege, or preference to any one, let's say any WTO member states, any WTO member state is giving immunity, privilege or preference to any other WTO member state. For example, A is a country who is giving certain concession to country B, and this concession has to be given with respect to a concept known as only on like products. So इसको कहाँ पे माना जाएगा? For example, I'll give you an example. Like products. Let's say certain concession is given on import and export of plastic toys. For example. So A is a WTO member country. वो किसको concession दे रहा है? B को. वो भी एक WTO member country है. MFN principle says that let's say if certain concession is given to one given by one WTO member country to another WTO member country, then this same concession on this same like product, which is plastic toys in this case, has to be given to all other WTO member countries. This is MFN. So no discrimination. But what is the catch on like products? Ab like product kya hai? We'll talk about that separately. Obviously, it should be same. Its consumption should be same. The objectives should be same. It should be have the same stack structure. So all of these are criteria to determine like products. But let's assume in this case, B is not a WTO member country, and still A is giving this concession to B as a bilateral agreement. But ये बाकी WTO member country को पता चल गया. All other WTO member country, let's say C, D, E, F, G, H, I, Z, okay, all of them are asking the same concession. Is that possible? Is it feasible? No. So MFN principle says that if one WTO member country gives certain concession to another WTO member country, same concession has to be provided to all other WTO member country. Hence, Article 14 and 15 applies together. मतलब हमारा Constitution का Article 14 and 15 drawing an analogy that there is equality without any discrimination. This is your MFN principle. Clear? Any doubts? Talking about national treatment. This is country A, this is country B, same. Let's say ये भी like products पे ही काम करता है. Let's say plastic toys. Now the plastic toys manufactured by companies in country A is exported to country B to be sold. अब इनके भी तो domestic manufacturers होंगे जो कि plastic toys बना रहे होंगे, right? So national treatment principle says that once a product or once a like product crosses the international frontier, now whatever tax or customs duties they pay here is fine. That is allowed. Whatever is allowed under national law is fine. Let's say whatever customs duty or import duty or जो भी उनको देना है वो दे दिए. Once this foreign product enters into this market, then country B will not discriminate with its own domestic product. So let's say I'm highlighting this in red color. This plastic toys of country B, coming from country A, will be treated as a foreign product in country B. और वहाँ के भी जो domestic manufacturers हैं वो plastic toys बना रहे होंगे, correct? This country B cannot make any law which will give any preference to these plastic toys. Or let's say this country B will not make any law which will impose additional burdens or additional tax or any additional, let's say, requirements on a foreign like product. This is the meaning of national treatment. Is this concept clear? If this concept is clear, again, let's go through the question. Explain the principles of most favored nation and national treatment in the international trade law. I hope now you will be able to address. Is it permissible for a WTO member state to impose different rates or of reciprocal tariffs on other member states of WTO? No. Okay. Can a member state affected by higher tariffs file a complaint with the dispute settlement body of WTO? Discuss. Yes. Clear? So if you know the concept, this long question will become easier for you to write. This is what I'm trying to explain. Okay? This is what we'll be doing throughout these lectures. I'll try to simplify as much as possible. Because if you go through the provisions of GATS and TRIPS, it will become very difficult. One more thing, when we talk about international trade law, let's say international trade law, then we have to study about trade with respect to goods under GATT, General Agreements of Tariff and Trade, with respect to services. This is what you have to study as part of the syllabus under General Agreement of Trade and Services. And what else? Intellectual property rights under which law? अरे अपना नहीं TRIPS. All of these are part of. Correct? I'm just explaining you the canvas. Are we in compliant with all of these? Yes, we are in compliant with TRIPS also, and hence we have made amendments or changes in our own IPR laws. And now we have enacted new legislations. Okay. ठीक है, चलो, let's discuss this answer. Any doubts? ट्रेड लॉ कॉलेज में पढ़ाया गया था, तभी आपको पता है. Did you take it as a part of your electives? All of you study trade law, clear with these concepts? Perfect. You have to highlight this. That is the essence of international trade law. On, do you think these two are an important point to be highlighted as part of the answer? Because this question is asking about a lot of things, hence reciprocal tariff, if provided to one country, also has to be ensured for all other WTO member states. Else remaining members can file complaint with DSP. More or less, you have addressed all the demand of the question effectively. But if you are not aware with respect to the basics, then nahi hoga. Again, this is the same thing. So all these concepts, national treatment, MFN, is available under all these three. ठीक है, जो basic principles हैं वो तीनों में common है. Obviously there would be some exceptions. Shall we move ahead? Shall we discuss some other questions due to paucity of time? Acha, this is important. When special treatment can be given to certain countries as an exception to MFN principle. This is important. You can give as a part of regional trade agreement under Article 24. So like free trade areas, customs unions are permitted under GATT if they eliminate trade barriers within the region. Okay? Preferential treatment can be given as an enabling clause, okay, which allows developed nations to offer preferential and non-reciprocal trade benefits to developing countries. Again, I remember the basics starting, developed and developing, hence this exception. This forms the legal basis for generalized system of preference, which allows LDCs to export goods at zero significantly, obviously reduce tariffs. Idea is to help the least developing and developing countries. Special provision for economic development under GATT 18, Article 18, allows developing nations to have flexible tariff structure and import controls designed specifically to support domestic industries and promote national economic development. Pre-existing international agreements, pre-existing, that is prior to 1st January, they will be given preference. So it says, for example, preferential treatment agreement under WIPO, World Intellectual Property Organization, is generally acceptable. Exception under GATS, so Article 14 of GATS allows member to introduce, maintain measure that would otherwise violate their MFN obligation. So these exceptions are available under GATT, GATS, and also TRIPS. Exception under TRIPS, same pre-existing agreements, specific agreements on judicial assistance or law enforcement, certain rights related to performers, phonograms, or broadcasting, or even, let's say, certain exceptions with respect to Paris and Berne Convention are still incorporated as TRIPS. Okay. Conclusion, thus MFN and national treatment principles forms the twin pillars of WTO framework, ensuring non-discrimination in global commerce, with certain exceptions being allowed under WTO framework. अब आते हैं क्रिमिनल लॉ पे. आई एम श्योर क्रिमिनल लॉ तो अच्छे से पढ़ा होगा. Can I ask some question? Define mens rea. Fair enough. Is mens rea necessary to be proved in every case in India? अच्छा ठीक है चलो. What are the constituents of mens rea? How will you determine that a person's mind is guilty? Is there any way to determine? Is there any machine? Ingredients of mens rea, correct. Are there any? Please remember this. This is the basics of criminal law. And these three are in a, if I put it from this to this, in an ascending order in terms of their degree. Meaning intention reflects the highest degree of guilty mind. And what does intention reflects? Active state of mind. क्या reflect करता है? Active state of mind and the desire to achieve the consequence at all cost. So we also have to understand what is actus reus. What is actus reus? Only act or something else? Act or omission. Okay. Let's say A tells X to give poison to B. X gave poison not to B but to C, thinking C was B. What is the actus reus here and what is the mens rea here? A asks X to give poison to B. X, thinking C to be B, gives poison to C. What is the ठीक है, correct. Obviously X has a guilty mind, but I did not say what happened after C had the poison. It turned out, second part of the illustration, it turned out this poison was actually a medicine. And hence, kuch nahi hua. You see how smartly I am changing the situations? Only to confuse you, nothing else. So when we talk about actus reus, we just need not understand from the perspective of act, but also from the perspective of its consequence. So I am telling you two examples of consequence. T को चलो हटा देते हैं. B took the poison. One instance, B did not die. Other instance, nothing happened. Is A still guilty? It depends. So guilty mind has to be understood in consonance with whatever the act happened and also its consequence. And here we are also talking about another concept of A instigated X, तभी तो X किया जाके. So you understand these three in their ascending order. So intention reflects active state of mind. Knowledge reflects passive state of mind. And knowledge means awareness of the consequence of the act. And reason to believe means awareness of the presence of the subject matter. So when you study or when you go through, first of all, these terms are defined under this term voluntarily, under BNS and IPC. Okay? And these terms also appear, if you go through IPC, most of the offenses. So the degree also helps you to determine the difference between culpable homicide and murder. So when you go through the definition of culpable homicide, इनका डिग्री अलग हो जाएगा. And when you go through the definition of murder, obviously that degree would be of a higher degree. So even knowledge under culpable homicide will be a lesser degree as compared to the knowledge under murder. So not only among themselves, but also within a complete block of an offense. That's why it's very important to understand this absolute basics. Now coming to this question of discuss the doctrine of transferred malice as applied to law relating to culpable homicide under IPC. Now this question was asked in 2023 and hence IPC does not matter. ठीक है, BNS may be here, but we need to understand the concept. What is this concept of transferred malice? Correct, absolutely correct. A trying to kill B, but C comes in between and C is killed. Now, A can very well, in his defense, say that see, my guilty mind, my mens rea was with respect to B. My act was with respect to B. Somehow, C came in between and hence the guilty mind and the act does not correlate. Can A take this defense? So to ensure that A is not able to take this defense, this provision is provided under law. This concept of transferred malice is provided under law. So if we talk about the structure with respect to this answer, the structure would be pretty simple. In the introduction, mention the provision. IPC, BNS, either. Okay. Obviously, explain transferred malice, give illustration, give observation of the courts, and you can conclude your answer. I don't think there is any difference here. The only point is that how you are able to explain the basics. That is the point. Any other way to explain this? So at least if you know what is transferred malice, explain it just like he said, explain it through an illustration. Give illustration if you remember from the Bayer Act. Okay. See, section 301 of IPC or 102 of BNS explains the concept of doctrine of transferred malice or transmigration of motive and makes the accused liable even if the person who died was not the one who he intended to kill. And then explain guilt of the accused, that why this provision is added, because the law intended to ensure that such a defense is not taken up by the accused. That obviously his guilty mind was not there to kill him. But yet if death happens, that death, killing of a person cannot go unpunished. And that is why these provisions highlight this concept of transferred malice. So it says intention is always a question of fact, and the fact that the accused did not intend to cause the injury he did might be a mitigating factor, maybe, but it does not mean he will go unpunished. Thus the essential ingredients that needs to be fulfilled when looking at cases of transferred malice are: accused has caused the death of another person. Now this itself is an offense under BNS or IPC. Accused caused such bodily injury which was likely to result in death. Accused caused death of some other person than one he had intended to kill. And the main objective behind this provision is to ensure that an accused is not set free by the court simply on the ground that they did not have the requisite mens rea. Ab kaun sa mens rea does not matter at all now. So this sort of malice, this bad faith, was transferred to the other person to whom he did not intend to kill. And then highlight the observation of different judgments. Thus, transfer of malice does not take into account intention or lack of it, of the killer. All it considers is whether death of the other person has happened or not. So this cannot be taken as a defense. Now see this question asked in the year 2024. Just explain me. I'm sure all of you have studied criminal law properly. So tell me what this question is asking. It is the degree of negligence. देखो आ गया ना degree. Similarly, question has been asked on degree of mens rea with respect to culpable homicide and murder. So you have to understand the importance of that degree. Degree of negligence, which really determines whether a particular action will amount to rash and negligent act, as required to hold a person guilty of homicide under section 304A of IPC discussed, asked in 2024. So what is this asking exactly? Tell me. So यहाँ आपसे वो ये जानना चाह रहा है कि आपको ये पता है कि नहीं पता है. Very simply. So it talks about what? Correct. Death by negligence. And when death by negligence takes place, then what happens? How is mens rea to be understood here? If you understand that, then I don't think there is anything else to be explained. See then, go through this first. Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment for a term which may extend to 5 years and shall also be liable to fine. And if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of a term which may extend to 10 years. Okay? So which is not amounting to culpable homicide. So what is the meaning of that term? See this. The death which has happened, it was not intentional. It just happened because of certain negligent act. And that's what the question is. It is the degree of negligence which is really determines whether a particular action will amount to rash and negligent act. Now, in such matters, actually, what the court has to determine whether it was a case of death caused by negligence or it was intentional murder. I'll give you an example. Let's say this is a railway crossing and a bus carrying school children. The driver is driving. This railway crossing is unmanned, not closed. And the bus driver, let's say he's hearing music at a very high volume. So he did not hear the coming sound of the train. Catch it, accident happens. And obviously, some of the students are killed, some of them are injured. Question is, under which offense the bus driver will be charged? Will he be charged for death caused by negligence, or will he be charged for culpable homicide, or will he be charged for murder? So generally in these cases, it is generally used as a form of a defense, because if this is the provision, obviously it reduces the number of sentence. It reduces this to maximum of 5 years. Whereas in culpable homicide, obviously it can go up to 10 years of or life imprisonment. Murder mein to you know. So the idea is whether it is culpable homicide or it is death caused by negligence, because if it is death caused by negligence, then at least one thing can be said for sure, that there was no mens rea, but that has to be proved. So burden of proof lies on the accused. Correct. Okay? So explain of this importance of degree of rashness or negligence, because this is what has been asked. This is the crux of the question. It is the degree of negligence which really determines whether a particular act would amount to rash and negligent act defined under this section. But how will anyone determine the degree? It will be based on, it will be a subjective evaluation based on facts and circumstances of the case. It is only when the rash and negligent act is of such a degree that the risk run by the doer of the act is very high, or is done with such recklessness and with total disregard and indifference to consequences of this act. See, consequences comes into picture here also. The act can be constituted as a rash and negligent. In Raghunath Bahish versus State of Orissa, court says, section 304 IPC limits itself to rash and negligent acts which cause death but fall short of culpable homicide. Very clearly, it cannot be culpable homicide, because once it is culpable homicide, it goes beyond rash and negligence act. So it means to ensure that it is confined within the concept of rash and negligent act, you have to highlight that the degree of recklessness was not very high. मतलब एक होता ना extremely negligent. So if one is extremely negligent, then yes, it's possible, it can be highlighted or it can be proved, but that depends. Mohammad Ainuddin versus State of AP, Supreme Court stressed that this document is only a rule of evidence to determine the onus of proof or owner of proof in actions relating to negligence. It has application only when nature of accident and attending circumstances would reasonably lead to belief that in absence of negligence, accident would not have occurred. Do you know the definition of good faith? There's a correlation. So if someone is doing something in good faith, it means he's taking due care. And absence of good faith means lack of care. And lack of care also is equivalent to negligence. But lack of care, which is equivalent to negligence, let's say leading to certain mishaps or deaths, it does not mean that that person had a guilty intent. So if to convert negligence to culpable homicide, you have to prove the element of mens rea. So generally in such instances, mens rea is missing. This is what you have to highlight. But see, courts have also resorted to culpable rashness or culpable negligence to overcome the difficulty in having proof of accidents and parties responsible in such accidents. So culpable rashness, again, it's a negative term, means they were criminally negligible, right? Culpable rashness lies in running the risk of doing an act with such recklessness and with such indifference as to its consequence. And criminal negligence is the failure to exercise duty with reasonable and proper care and precaution, guarding against injury to public generally or to any individual in particular. What did the court say in Naresh Giri versus State of MP? Where death and injury caused to passengers when the bus driver attempted to cross an unmanned railway crossing and was hit by a passing train. Same example. Supreme Court altered the charges from culpable homicide not amounting to murder to death caused by negligence. Why? Court held that negligence and rashness to be punishable under section 304A must be attributable to the state of mind where criminality arises. So you have to see कि actual में guilty mind means intention, bad intention से criminality arise हुआ कि नहीं हुआ. Because of no error in judgment but a deliberation in the mind, risking the crime as well as lives of people. So that again, do you think it's a very subjective thing? And hence the degree. Okay? So this is what you have to explain. So always remember, whenever you go through the question, see these terms of the question or the statements which is written. That is the purpose of this discussion also. Not just to give you a structure, not to just explain you case laws, वो आप ऐसे भी पढ़ सकते हो, but to make you understand that when a statement is asked in a question, that statement has value. And that statement needs to be explained. So let's say you explain everything about death caused by negligence, आप दे दिए, judgments भी दे दिए, but आपने ये वाला part नहीं explain किया, तो marks नहीं आएगा. It's as simple as that, right? Conclusion, therefore, to determine whether an act or omission falls outside the scope of culpable homicide, murder, or even accident, one needs to determine the degree of rashness or negligence based on which a conclusive proof can be drawn. ठीक है? Again, highlighting the same point. कुछ questions देख लेते हैं. I think getting late, all of you. Yeah. Let's see. This question was also asked last. Just tell me what this question is asking. Again, the same part. Question says, doctrine of forcibility, not the proximity, is a correct test of remoteness. Explain with the help of case laws. Any idea which part of torts this question is from? This question is from the topic of negligence. See, when we talk about any negligence, here also it's the same thing. Some act happened and it acts has a direct consequence. Okay? Suppose a person was required to fill the ship with certain drums of petrol and benzene. Now both are inflammable substance. ठीक है? and hence due care needs to be done. Now, the person who was supposed to, fill these in a ship, he was, let's say, slightly careless. And because of that, one of the drum fell. And because these drums fell, it caused a spark. And because of the spark, it was inflammable. The whole ship caught fire. So what was the act, or what was the negligence? That these drums fell. The drums fell, leading to a spark. Spark led to catching of fire on the whole ship. So two type of test has been determined by the courts. One test is foreseeability test, that whether this instance was foreseeable or not to the person because of whose negligent act this happened. And another is a test of directness, or direct result of negligence. Basically, this question has been asked because the test of foreseeability was determined by Wagon Mount case. And test of proximity, that is directness, was determined by Re-Polymis case. And in Re-Polymis case, test of this directness was applied, that is whether the resultant act or resultant concept was a direct consequence. Let's say fire which happened, was it a direct consequence of the negligent act of the concerned person? So this was directness test. But later the courts in UK declared that this directness test is not the correct test to determine liability, but test of forcibility, whether it was forcible to any person or not. So this is what has been asked last year. This is again another concept of negligence. So you understand, UPSC is trying to test you from the very basics, right? So same here, both forcibility and proximity or directness test is used to determine liability for negligent acts resulting in damage to the plaintiff. Courts earlier used the directness test in Re-Polymis, but later on Wagon Mount. So you explain directness test, you explain proximity test, you explain in fact neighborhood principle also, explain the content of these two cases, and then you conclude your answer. So this should be the stated structure with respect to your answer to this question. I just want to discuss see this conclusion. So when is this proximity ends? Actually, this is a classic example. A was smoking a cigarette, and on the fag end of the cigarette, he threw it on B. B saw that burning fag end, threw it on C. C threw it on D. And because of this, let's say it caught fire and D got injured, and also it resulted to burn of the marketplace. The question is, if D got injured here, was A responsible? In this case, it was said that it was the direct consequence, that fire was the direct consequence of this person throwing. So had this person not thrown this, he would not have done that. So you trace back to this. But again, the question is to how far can we trace? Okay? So it has to be there has to be certain connection between the negligent act and the resultant consequence and its harm. Okay, clear? And this is where the both test of directness and test of forcibility comes. Now there are two words, proximate cause. A cause can be proximate or a cause can be remote. Proximate means a direct result, same point, and remote means too far. So test is generally applied to find out whether the consequence which resulted in certain harm was was that a proximate cause or a remote cause? So the courts have said the best way to determine is the concept of foreseeability. Could A foresee that if he throws something like that, it will catch fire and harm anyone? The answer is yes. And hence A can be said to be liable with respect to, let's say, the concept of foreseeability. Is this clear, this concept? ये तो कॉलेज में पढ़ा होगा. Perfect. Okay. Product liability rule. Have you heard about this concept of product liability rule? No. Earlier, under Consumer Protection Act of 1986, the concept was buyers beware. Buyers beware. I'm just explaining you the concepts. So while purchasing a product, it was the consumers who had to be very much aware. They have to look expired hai ki nahi hai, defective hai ki nahi hai, all those things. But the Consumer Protection Act of 2019 has reversed this concept. Consumer Protection Act of 2019 addresses or expands the rights of the consumers. So it also includes various online transactions. Let's say you purchase anything from Myntra, Amazon, Swiggy, etc. Or you make any transactions, let's say on Paytm, Google Pay, etc. All of these are now part of Consumer Protection Act. And not only that, it has converted this whole idea of buyers beware on its head to seller beware. Means the sellers now cannot give you a defective product, and hence it provides for a liability known as product liability rules. And obviously it makes किसको liable मनाया जाता है इस केस में? Not just the seller. This is what you have to explain. So if we talk about the structurization of this answer, very straightforward. आप introduction में ये change बताओगे, the change which has taken place through CPA 2019. Why it has changed? Because it has given more rights to the consumers. So you start by mentioning the provisions under CPA which provide for this product liability rules. Correct? So what are the provisions it provides? I'm just giving you the highlights. So who is now liable now? Product manufacturer. Let's say the manufacturer makes a faulty product. Obviously they will be liable. Product seller. Now there can be two instances. Product manufacturer is also the product seller, or the product seller is not the product manufacturer. इस case में, I'll just give you an example. Let's say the product seller is someone else and manufacturer is someone else. For example, let's say गीजर है ना. अब मैन्युफैक्चरर ने गीजर पे 2 साल का वारंटी दिया, फॉर एग्जाम्पल. अब सेलर को obviously has to sell the product. Now he sees कि नहीं, the product is not being sold. What he does, he gives, let's say, a 3-year warranty. Is this warranty given by the manufacturer? And let's say because of this, if some short circuits or some harm happens in the product itself, because it was not provided by the main manufacturer, this person or this seller will be liable. Okay. When will this liability arise? If because of any defective product or services, because it also includes services, if it either physically harms the consumer or it injures the consumer, or injury, यहाँ पे legal injury भी हो रही है. Let's say deficiency in services. What was promised was not delivered. Then we have obviously liability for service provider. So all of these have been provided. So do you agree now? Buyers beware or caveat emptor has been changed to caveat vendita. You understand now this concept? Yeah. The rule of buyers beware has been shifted to caveat emptor under CPA 2019 based on introduction of product liability rules. Chapter 6 has laid down elaborate rules. So provide for that. Explain all of those rules. Product liability action may under section 83 may be brought before either of the district, state or national consumer forums. And these again are examples of liability of product manufacturer. See, if the product contains manufacturing defect, if the product is defective in design, if there is a deviation from manufacturing specification, all of that is an example. Liability of service provider, service provided by him was faulty or imperfect or deficient or inadequate. There was an act of omission or commission or negligence or conscious withholding of any information which may impact or affect the service or the consumer. Service provider did not issue adequate instructions. Liability of product seller, all of these are liability of the product sellers. If there is any change in the product, if he provides, if there is no information provided with respect, he is selling a product, but uska manufacturer ka koi information nahi hai. He is changing the warranty of the product. All of these, for all of these, the seller will be made liable. And hence, the liability rules has shifted. What are the remedies which are available? If case is filed, removal of defect, replacement of product, return of price paid by consumer, compensation to consumer, including punitive damages, discontinuation of these unfair trade practices, withdrawal of hazardous or unsafe goods, direction to cease to manufacture hazardous goods, all of that, compensation for product liability action. So conclude, since the 2019 Act aims to provide enhanced protection to consumers, it accordingly provides for more stringent punishments for the sellers of product or services as compared to CP. Okay. Let's take just one more question on the safe harbor principles, because new law has been made. Rest, I'm sure you can go through. Questions are based on Contract Act and all of that. So let's just take up the last question. See this, asked in 2023, again was asked in 2024. So, and a new law has been made in 2026. First of all, just let's go through the question. It says, under what circumstances can an intermediary be held liable for third-party content hosted by them? So this forms part of Information Technology Act or part of contemporary legal development. Explain the liability of intermediaries in the light of the relevant legal provision in the IT Act and other contemporary developments. Fits the bill. Who is a third party or who is an intermediary here? Can you give an example? How do we understand this concept? Correct. So give an example. Who can be said to be a platform provider? Perfect. Facebook, Instagram, or YouTube. So these are providing a platforms. Let's say we post a video, I post a video. So I'll be liable. So if I post something which is, let's say, illegal, not allowed, it's an offense. So these are called intermediaries. Who are intermediaries? Service provider. Internet service provider or social media platform. Let's say. कौन है ये? Internet service provider. So for example, Airtel or Reliance Jio or social media platform. ठीक है, intermediary तो clear हो गया. So it's saying, under what circumstances can an intermediary be held liable for third-party content hosted by them? So what is a third-party content? Let's say we made a reel, we posted it on Instagram. Now Instagram is a company governed, I think, by Meta, right? तो ये एक अलग कंपनी है. हमने अपना रील बना के इसके सोशल मीडिया प्लेटफॉर्म पे डाल दिया. So we are the so-called third party, and hence if we provide, let's say, any wrong material which is an offense under our country, then the question is that, is this social media platform which does not even know us, उसने बस हमें अपना प्लेटफॉर्म दिया है यूज करने के लिए, will this social media platform be responsible for any wrong content provided by a third party? This is the question. Mhm. 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 Correct. Mhm. Correct. 79, 79, 79. Correct. See, this so-called safe harbor clause has undergone a lot of transformation with respect to the successive changes in IT rules. पहले क्या आया? IT rules 2011. It made certain changes, let's say. Then came IT rules 2021. Now, from here onwards, the concept started changing. Earlier, the concept was, you can say, it was not, the social media intermediaries were not made actively responsible. They were passively responsible once an act has occurred. So let's say someone posted something which was offensive on their platform, तो या तो गवर्नमेंट या तो कोर्ट उनको ऑर्डर देता, किस चीज का ऑर्डर देता? टू टेक डाउन द कंटेंट, टू टेक डाउन द content. And once they had actual knowledge of this fact that yes, they have to take down the content, वो अपने प्लेटफॉर्म से उसको हटा देते. So what is the point which comes into picture? Actual knowledge. So social media platform, when they would have been responsible for third party content, जब कोर्ट या गवर्नमेंट का ऑर्डर आ जाता और उसके बावजूद भी वो कंटेंट नहीं हटाते, means that when they had actual knowledge, still they did not or they do not take down the content. So the meaning or the legal meaning of this word actual knowledge became very significant. Also discussed in Shreya Singhal judgment, that what is the true meaning of this word actual knowledge. The court said bhai tabhi hoga jab ye denge. So you can say here the approach was remedial, कि एक बार सरकार या कोर्ट say something and then obviously they will take down the content. 2021 it started changing this approach. It created a tiered hierarchy and it created a type of social media intermediary referred as significant social media intermediary. Now who are intermediary? Who are significant social media intermediary? Who has a registered user of 50 lakhs or more. Who has a registered user of 50 lakh or more. These significant social media intermediaries were given additional responsibilities. And now their job in terms of actual knowledge from being passive became active. And they were given also the power of regulation or guidance. Now comes the IT rules of 2026. Now why IT rules 2026 is more important? Because of lot of artificial intelligence generated reels. Because it is very difficult to, actually when you see something, I find it very difficult to relate whether it is actual or use of AI. So it is now referred as synthetically generated document. So basically generated by artificial intelligence. With respect to these AI generated documents, which is posted on social media platforms, it has been now the duty of significant social media intermediary is no more passive, but has become active. And if they put anything on the platform, they have to categorize that it is made with the help of AI. If they do not do it, this can take it down. So now this concept of actual knowledge has been turned on its head from being passive to be very active. Okay? And hence, if we look at this part of the question, from our present perspective, contemporary development, so to बहुत सारे contemporary developments हैं. So if I take you here, so this is the new rules. IT Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendment Rules 2026. Just let's go through the basics. Okay? The purpose is to ensure an open, safe, trusted and accountable internet for citizens availing internet-enabled services. Okay? And there's a need to regulate advances in artificial intelligence and machine learning technologies which produce synthetically generated information. Benefits, obviously it enables innovation, ensures economic growth, supports creation of multilingual and local language content, enables assistive technologies for persons with disabilities, lot of benefits. Fine. Concerns. Growing misuse of SGI. What is SGI? Synthetically generated information. That is information generated with the help of artificial intelligence. It is with respect to these synthetically generated artificial information whereby greater regulation is required. So, कहने का मतलब है कि whatever earlier safe harbor principles were provided to these intermediaries, those benefits are not available in the way it was provided earlier. And hence there has been a change in entire jurisprudence from being mere passive to active. Now it is clear to you, all of you. Misinformation, other unlawful content capable of obviously misleading the users. To address these changes or these concerns, the MeitY has introduced these rules. These rules came into force on 20th February 2026. Important highlights: insertion of definition relating to audio-visual or audio-visual information synthetically generated, because they have to categorize na what is the meaning of synthetically generated information. Strengthening of user awareness obligations, including periodic user information at least once every 3 months. So a lot of obligations have been imposed on these social media intermediaries. Strengthening of timelines for compliance, including reduced timelines for takedown upon actual knowledge. Earlier it was 36 hours, now it is 24 hours. Introduction of a dedicated SGI due diligence framework under Rule 3 Clause 3, including measures to prevent unlawful prohibited SGI and labeling or metadata identifier obligations. Basically to regulate all these SGI content, and additional due diligence obligation for significant social media intermediaries, including user declaration and technical verification before publishing SGI and prominent labeling. This is the change which has happened. So is this clear now? Okay. So according to, so section 79 is actually the main provision under IT Act, whereby we understand the power of or the provisions with respect to safe harbor principles. So according to section 79 of IT Act, any intermediary shall not be held legally or otherwise liable for any third-party information, data or communication link made available or hosted on its platform. However, under section 79(3), there are certain circumstances when an intermediary can be held liable, and obviously the change is introduced. Okay? So this is what इसका आंसर आज के कॉन्टेक्स्ट में काफी चेंज हो जाएगा. So now we have to highlight these changes, these activeness shown or these provisions or ensured. So all of these are changes. See, the 2025 rule or 26 rule has significantly changed the application of section 79 of the Act by removing the Good Samaritan protection for intermediaries voluntarily removing content, because now they have to ask or ensure that AI has been labeled, and if not, they can take it down. And another important term, then it explains intermediary. See this. So generally, intermediaries were granted a safe harbor from liability for content posted by their users, but this protection is not absolute, of course, and they can lose this protection and held liable if they conspire, abet, aid, or induce the commission of an unlawful act, or if they fail to expeditiously remove or disable access. But this was based on prior information, right? So when intermediary will be liable for hosting third-party information, then when they have conspired or abetted or aided or induced upon receiving actual knowledge. Now the problem is that what is the true meaning of this word actual knowledge? after introduction of the 2021 rules. So it says the legal shield which was earlier available to intermediaries under section 79 is no longer available. Clearly, SSMI platforms with more than 50 lakh registered users in India has been obligated to do the following. So SSMIs must require users to declare whether their uploaded content is synthetically generated, and they must deploy reasonably and appropriate technical measures, including automated tools or other mechanism to verify accuracy of such declaration. Now this brings another problem. Having such technology, so it means these SSMIs will have to invest to ensure that they have those automated tools, whereby they can by themselves detect AI material and find out whether it has been declared that whether those materials are AI. So the problem is with respect to the change in understanding of this word actual knowledge. What was highlighted in Shreya Singhal? Supreme Court held that an intermediary acquires actual knowledge on lawful content, thereby triggering an obligation to take it down only when it receives a court or government order directing its removal. This cannot be said anymore. This understanding has also been metamorphized. It has been transformed. So again, all of this. So as a conclusion, we can say IT guidelines rules changes the passive notice and takedown mindset and propel the SSMIs towards proactive governance, especially for synthetically generated online content. Okay? You're clear now with this new concept of social media intermediaries? This is the latest concept, by the way, because these rules have been notified. It's quite possible that this year itself, let's say a question is asked that how or what were the changes being introduced, let's say with respect to 2011, 2021 and 2026. So this can also be asked, that how these rules keep on modifying the, you can say, the obligations of significant social media intermediaries. This can definitely be asked. So in that sense, this topic becomes important. So I hope through these discussions, we have taken a lot of time, but still the idea was to make you understand the purpose of these 20 lectures. Consider these questions which we have discussed as an addition, because hopefully I will not be taking up these questions again. If these questions again discussed, obviously now you know whatever is left behind, we can take up those discussions. So we have distributed this entire topic into these 20 classes, and the idea is, again, I'll take up these question wise only. Try to use as much as possible the PYQs to make you realize and understand what UPSC is actually asking and what is the actual demand, and then how you apply the concepts. See, you know the concepts, right? Aisa nahi hai ki you do not know. Obviously, you know. All you need is a little bit of refinement, little bit of revision, and then the application of those concepts into how you write those answers, right? So with this, we come to a conclusion to this orientation session. Thank you very much.